I went to the Andrew F. Oral argument, and it was quite interesting to see. It's always dangerous, as those of you in the room who are lawyers know, to try to judge what the opinion is going to be, or even which side it comes out on based on the oral argument. And particularly with this Supreme Court, and frankly with its two predecessors, even more so. But I did actually have a pretty good feeling about how it was going to come out based on the kinds of questions that were presented. But my favorite part of the argument was when the lawyer for the school district, Neil Katyal, who's a very well-regarded acting solicitor general for some reason that probably relates to the fact that he works for Hogan and Lovells on the side, representing school districts. So at some point, and some of you, we heard a little bit about this today, the argument that the school district was making, and that the 10th Circuit had, and other circuits had accepted, was that all that IDEA requires is above de minimis level of education. So if there's a substantive standard, it's about as low as it can go. So it's just above de minimis, and they kept saying that. And Justice Alito asked a question at one point to Katyal and said, well, what do you mean by just above de minimis? And again, if you've ever done oral arguments, I love the argument about moot court arguing both sides. He thought, I think, maybe he just lost his train of thought, did Katyal, and so he said in response to that question, well, Your Honor, de minimis is Latin for very minor. And Alito, I would say Alito looking at Katyal kind of the way Alito looked at President Obama when Obama criticized Citizens United. If you remember that, and Alito kept saying no. Well, he didn't say no, but he did say in a rather steely way, I know what de minimis means. I kind of thought at that point we probably had won or something like that. There's nothing else with that. So a couple of things, and I want to talk a little bit about not so much about Andrew, but really about Tom. And since so much of today, I think, particularly talking about Park, is for some of us going back in prehistory. I was trying to think about this. So, well, I first met Tom and Frank. Well, I wasn't 4, however, when some of this happened. So I met Tom and Frank and the other folks, not in the Park case, but in the Pennhurst case. So I was working at Civil Rights Division of Justice. I did not work on the trial side of Pennhurst. We were an intervener, as was Park in Pennhurst. But I worked on after Judge Broderick issued his initial decision, on the implementation side. So when meeting about a proposed plan of implementation, I remember just some of the phrasing. Those of you who work with Tom know that while you're there drafting with him, at some point, and I was really surprised this didn't happen today, he would jump on a chair kind of in lotus-like and opine about things. So maybe that's a change over time, but I was kind of waiting to see that today. But it was interesting meeting these folks because I had done, the cases I had worked on had been on in Alabama, the Wyatt case, sort of one of the landmark cases in this field, a very long right to treatment case in Puerto Rico, another case in Nebraska. And I would say that Judge Johnson in the Wyatt case is a definite counterexample. The other judges weren't always, judges that had the qualities that Tom was describing earlier. So I come to this meeting, of the parties in the Pennhurst case, and this is like a 3-ring circus. There's Judge Broderick up there kind of orchestrating everything. There's the plaintiff's attorney, there's the plaintiff intervener attorney, there's the defense attorney, there's the 5 county attorneys. I mean, I'm from New York. What did I know about Bucks County and Delaware County and all these kinds of places? And it was just remarkable watching all these people. But what was particularly impressive, knowing how our activities in Alabama and otherwise had gone, is that Judge Broderick, no radical by any means, I guess moderate to liberal Republican perhaps, when he was lieutenant governor, had clearly been educated. He'd clearly been, I want to say schooled, but perhaps more generously to him, educated by a group of lawyers who understood how you marshal evidence, how you don't just make a kind of abstract argument about why institutions are bad, but you make the case by bringing forward the stories of the Nancy Beth Bowmans and Nicholas Romeos and all the other people who we know who have been in these institutions. And that was certainly a lesson that we at Justice learned as well in Alabama, that is, grab them first with unfortunately, all the horrible things that are happening, and then start talking about the fact that it doesn't have to be this way. And so one of the things that I think I take from today's discussion is that importance that wherever we are now, wherever you think we are in terms of the quality of services and everything else, that those things that aren't the way you want them to be, don't have to be that way. And I thought the movie we saw, the short, was just amazing, watching this little girl play the piano and go from, okay, we can tolerate her in the classroom, I think, to being the star of the show. And what a wonderful, wonderful story. When I knew I was going to be here today, I also just decided, well, I should go back, and I remember this book that a friend of Tom's wrote a chapter in the Interest of Children. It was an article about, it was a chapter about, or several chapters about Pennhurst. It was called Pennhurst, a Parable by the late Bo Burt from Yale Law School. And he described how Park's role he described many things, and Park's role in Pennhurst and Tom's role in particular in working to broaden the case from an institutional improvement case to a close the institution case. And I think that was a critical step. And again, a sort of a moment in the field that moved from let's make it better, that was certainly more of a Wyatt focus where I was involved, to it can't get better enough. And from that, I knew from my own experience with looking at institutions in Alabama why there were certain things about institutions that would never be good, no matter how much the services got better. One of my favorite stories from that time was they were trying to teach at Partlow State Hospital, which was a Pennhurst equivalent. They were trying to teach people about how to cross the street and how to look at follow when the lights were green. And they had a part of the campus, they had to set up a little stop light, and red is stop and green is go. And so the training was, whenever it's green, you go. Whenever it's red, you stop. Problem, no cars were passing at any of this time. Again, maybe in Alabama, people obeyed traffic lights, but not so much in some other places, certainly not in Washington and not in New York. The other thing they did, by the way, they were trying to teach people how to handle money. They didn't have a lot of money, so they photocopied US currency. And I had a lot of delight in saying to the staff there, there's two problems. One, it's not a color printer, and so it may not really help these people figure out what money is. And here's another little problem. It's against the law to photocopy currency. So I think, and maybe as we've heard more recently, I wanted to say to them, you should probably get a lawyer at this point. But anyway, so you couldn't make institutions better, but it really took a kind of insight to understand the cultural, political, legal moment of that time. Because, again, looking back at it from this perspective, it is remarkable to think the period from like 1971 or so, really to about 1979 or 80, where all of a sudden, cases are being brought, made up, things that are made up that people just were creative about. And it's an extraordinary time which still we are benefiting from the insights there. And of course, particularly because of the discussion today about Park, Tom's insight about that there is and should be a right to education, that's the right to be pushing, is really a critical one. And I think we heard today how it's something we need to kind of go back to and think about, and not just accept the kind of incremental limitations that perhaps we become used to, but to still think boldly and to not just assume that that's not a possibility. Now, having absolutely nothing to do with this symposium, I've been reading recently one of two books that came out in the last few years about autism, both really quite wonderful. One is Neurotribes, if you don't know that book, it's a really terrific book. And the other is a book called In a Different Key, The Story of Autism, and it's by John Donovan and Karen Zucker. I would say different kind of book from the other one, but still very interesting in terms of the history of autism and autism activism and advocacy and many of the concerns. And as I'm reading along, what do I find but all of a sudden Tom Gilhul shows up here. I say, Tom Gilhul with autism, what's that about? So first of all, there's this description of Tom, and maybe you can help me figure out a little bit what this means. So this is now talking about the parents in Park going to see Tom and saying to Tom, we want you to bring a case, and Tom saying, let me think about it. It says, Gilhul was an intellectual tortoise. He spent most of that year reading widely, talking with experts and activists in the field of intellectual disability, and thinking through the kinds of constitutional arguments that would move him if he were a judge. Now, maybe tortoise is maybe that, I don't know, you went underground for 9 months or something. I couldn't quite tell. So, because I don't think of you as a tortoise, but anyway, according to the authors, he was. But the key was that when approached, it was, okay, I'm not just going to dash this off and sort of let's file a lawsuit and see what happens. We're going to think this through. We're going to think it through carefully, which even in today's presentation, you could tell that, anyone who knows Tom knows that he rarely does things just off the cuff. There's careful thought, there's activism, there's urging, there's thought. And so there was then the discussion of Park and how that, but of course that wasn't the key part of the book, which is about autism. So what I didn't know was that when then Tom was out in California before he came back and took over Pillcott, and he wound up meeting a couple who had a child with autism and who was very interested. It was I think Connie and Harvin and Lapin, and he met them, and they said, kind of, we want what you want. We want what you just got for the parents of children with intellectual disabilities. What do you think? And they consulted with Tom and I guess became friendly with Tom, and they filed a lawsuit. And then, because it was LA, instead of having to go with a lawsuit, somebody who knew Ronald Reagan, picked up the phone and said, you ought to sign this bill that the legislature just passed, because he had an opportunity, of course, to veto it. They did sign it. They didn't need to have the lawsuit.